and the agree, the learned senior counsel for number 3. Paragraph. You have noticed that nowadays it has become a trend amongst the lawyers to criticize the judges of the High Court or the trial court for no reason. Also, it has also become a trend that whenever a matter involves a political figure in a particular state, to allege that in that state, petitioner may not get justice and therefore seek a transfer of the proceedings from that state to any other state. Such practices cannot be permitted to continue. The judges of the High Court are also constitutional functionaries. They enjoy the same immunity as is enjoyed by the judges of the Supreme Court. Paragraph. Under the constitutional scheme, the judges of the High Court are in no way inferior to the judges of the Supreme Court. Also, though as an appellate court, the High Court to the Supreme Court can reverse, modify, affirm, reverse, modify the judgment of the High Court. Also, it has no administrative control over either the administration of the High Court or the judges of the High Court. Also, paragraph. As such, when scandalous allegations are made against the judges, it becomes the duty of this court to protect the judges of the High Court. Also, the perusal of the affidavit of apology would reveal that the apology is tendered only to this court. In our view, the contemptuous allegations are made against the judge of the High Court. Therefore, it would have been more appropriate for the petitioners to tender an apology to the learned judge of the High Court. Paragraph. We therefore permit the petitioner to tender. Well, we therefore permit the respondent to permit the unconditional apology before the learned judge of the High Court. Paragraph. Since the criminal petition number 4162 of 2020 is already disposed of, we direct the Registrar General of the High Court to reopen the said matter and place the same before the learned judge who had passed the final order in the said petition. On reopening of the said proceeding before the learned judge, the petitioners, the same shall be done within a period of 1 week from today. Yes. On reopening of the said proceedings, the respondents shall tender an unconditional apology before the learned single judge within a period of 1 week of the reopening of the matter. Also, the learned single judge would decide the question of acceptance of the apology within a period of 1 week thereafter. Paragraph. We will consider the issue with regard to acceptance of apology tendered to this court by the petitioners after the matter is disposed of by this court. Paragraph. Time and again, we have repeated that the courts had no pleasure in penalizing or sentencing the lawyers for acting in a manner which would amount to contempt of this court. Recently, a 3 judges bench of this court, to which two of us, Vijay and Justice Chandran, were a party, deciding a reference with regard to the difference of opinion between two learned judges of this court with regard to a sentence imposed on two lawyers of this court, had observed that the magnanimity of justice lies in not punishing someone, but in forgiving someone for the mistakes committed by the lawyers. So we had therefore agreed with the view taken by the learned judge, who had accepted the apology tendered by the lawyers. Paragraph. While we decide the matter, in the next bit will be guided by observations made by this is to.
Very grateful. One more line, but only name is.
Opening only for the purpose of only for the purpose of accepting the apology.
We are very grateful. One more small submission subject to my lord's appreciating. The Lord Justice may accept our unconditional apology.
We are saying that we will consider after 4 weeks. We are not closing the matter. We have observed in the subsequent paragraph as to what is likely to be done by us.
We feel really very sad, my lords, what is happening.
Your Lord, may permit us to file an affidavit of apology before the High Court. My lords,
yes.
So that is what we have said. Though the matter is closed,
yes,
we have directed the Registrar General of the High Court to reopen the matter only for the limited aspect of accepting the apology.
yes, my lords.
For filing the apology.
Yes, only filing, because sometimes the High Court may say that personal appearance, etc., etc.
No.
So that
Needless to say that the parties will be at liberty to file affidavit apology through email and so on. If necessary, the learned judge may consider permitting the parties to appear to video conference.
obligements. Very grateful. I was noticing that in 1954 there was a High Court of Nagpur. Maybe
Maharashtra.
In 1960, there was no High
yes,
Court of
my lords,
Nagpur.
then the reorganization.
In the reorganization, so the Jabalpur, the MP High Court is successor of Nagpur bench.
Yes, please, my lord.
Nagpur High Court.
Yes, my lords. Central India. Central
Earlier CP and Berar, then Madhya Bharat.
Very
Then on reorganization, that area went to MP, Madhya Pradesh.
Please, my lords.
My friend is very weak in
Read
Justice
my own possible.
Hidayatullah. Justice Hidayatullah.
Get the entire story.
Please,
So how he shifted everything from first he took oaths at Bhopal, then the entire night he travelled by road to Jabalpur because he had to administer the oath to the other judges the very next day. Otherwise, he would have been the only judge, and there would have been a gap of some days between the judges. Because it was only the Nagpur judges who had transferred to the MP High Court, and then shifting of the entire library and all that.
One anecdote about Honorable Justice Vivian Bose. I may take half a minute only.
Yes.
Only half a minute. The bench was hearing a case under PC Act receipt. The defense was that money was thrusted into the pocket of the accused. That was the defense. The junior judge was asking, how is it possible to thrust the money? So bench went for lunch. When they again reassembled, Honorable Justice Vivian Bose asked the other judge, you see your pocket. In the pocket there was a 10 rupee note. He said, this is thrusting.
no, Justice Vivian Bose was actually a professional magician as well.
Yes, yes. He wore many hats. He was He an active member of Scouts. Then he used to cycle around all the way from Nagpur to Pachmadi.
Yes.
Then he used to drive from Delhi to London.
He gave us that famous quote that the law is for the butcher, the baker, and the
I think both Vivian Bose and Justice Hidayatullah and their wives, their spouses, all four of them traveled together from Delhi to London.
Birsa Singh holds the field even after so many number of decades. Birsa Singh case.
Birsa Singh.
Birsa Singh.
Till today it holds the field. How many years?
Just in vacation, you read that. It's a very interesting reading. And there is a one special chapter on Justice Bobde's grandfather, M.R. Bobde. He describes him as the best lawyer that he has. He says that Nagpur had many eminent and very good lawyers. The best among them was M.R. Bobde. But why did they choose only Nagpur bench of the Bombay High Court?
That's a no.
Well, Mr. Mishram practices throughout the country. His jurisdiction is not restricted only to Nagpur.
He made a mistake. It is not the quantity of time that a judge pays or shows he is paying attention. It's the quality of attention that matters. That's all. I'm grateful.
Please, Your Lordship. My Lord's High Court, though relegated the matter to the trial court, has virtually clipped the wings of the trial court now.
Though we are not inclined to entertain the present petition, in as much as the High Court has remanded the matter to the learned single judge, to the learned trial judge for considering the application of which under 319, we direct the learned trial judge not to be influenced by any of the observations made by the learned single judge in the impugn order, and we further direct that the learned trial judge to decide the application under 319 on its own merit without taking into consideration the observations made by the High Court.
So the only thing is, my Lord, the fourth direction, my Lord. Till the exercise above is over, the aforenamed witnesses shall not be examined by the prosecutor.
You will learned trial judge will decide it with expedition.
Otherwise, no difficulty about that. Only thing is that, my Lord, the trial court will not be permitted to examine the witnesses. My Lord, the three witnesses are parted witnesses. And my Lord, this,
We direct the learned trial judge to decide the application on remand in a period of 2 weeks.
Lords, my Lord, trial may be allowed to proceed with regard to other witnesses. Because a trial should not come to a standstill.
Needless to state that, except there are only 2 witnesses who are concerned.
Three witnesses.
Except the witnesses about whom the 319 proceedings are pending, the learned trial judge would proceed with the trial insofar as other witnesses are concerned.
Grateful.
I pray before my lords to permit the petitioner, Mr. Ghanshyam Upadhyay, to address the honorable court. He is himself a seasoned advocate. Lords.
How much cost, Mr. Upadhyay?
Cost, my lord?
Yes. In the Bombay High Court, उसमें वो जो अभी जजमेंट किया था मैडम को, उसमें 1-2 पैराग्राफ ऐड करने को I think so.
तो ठीक है
Yes, my lord.
Is the Bombay High Court closed?
My lord, not, my lord, that is not the issue, my lord. My lord, kindly help me to see the.
Why should we disbelieve our High Court judges?
Lord, I am not that respect, my lord. My lord, kindly, my lord, see the relief which I am seeking for this honorable court. It cannot be granted by the High Court, my lord. See, my lord.
It can't be granted by the High Court.
Yes, my lord, kindly, my lord, see prayer clause C, my lord. I am seeking a very larger issue, my lord. Prayer clause C of the petition, my lord. Not only just registration of the FIR, my lord. But this can be granted only by this honorable court under Article 142, my lord.
Direct the Election Commission of Indian Election Commission of all the states in the country to formulate a scheme policy in coordination with each others to have watch and control on such illegal activities of political outputs, political parties of the country, which endanger or tend to endanger sovereignty, integrity, and unity of India, and withdraw. Why can't the High Court grant it under Article 226?
My lord, High Court, my lord, can have, my lord, jurisdiction only with regard to, my lord, Election Commission for the state of Maharashtra, but not for all other state.
The High Courts will have jurisdiction wherever a part of cause of action arises in that court.
My lord, but my lord, it will be not beyond the, my lord, jurisdiction of the High Court, perhaps, my lord, direct all the other state commission, my lord.
The present petition is
Lord-
nothing else but a publicity interest litigation. Paragraph.
My lord, may I say something, my lord? Just, yes, my lord. My lord, just, my lord, just, my lord.
Upal, you have already been once in Bombay. Do you want some such observations to be repeated?
My lord, just, my lord, I'm, my lord,
Just
advance.
for the sake of publicity, don't go on filing such petitions.
Lord, your lordship may not say so, my lord, see the gravity of the matter, my lord.
We are aware about that.
Your lordship may not, my lord, brand me for publicity, my lord, I have not done.
Can such a grievance not be raised before the High Court?
My lord, kindly see the relief which I am seeking. Under that impression, Lord, I came before this court. Lord, kindly, Lord, this honorable court, Lord. Yes, your lordship may hear me, Lord, sometime, Lord. Your lordship give me some hearing, my lord.
The present public interest will
Your lordship may just give me some hearing, my lord. Some indulgence, my lord. Some indulgence, my lord. Some indulgence.
nothing else but an attempt, but a publicity interest litigation.
My lord, just permit, Lord, to some, my lord, indulgence, my lord. Some indulgence, some indulgence.
So we have time and again observed that for protecting the rights of the citizens, the public interest litigation is necessary. At the same time, we have frowned upon the judicial adventurism and judicial terrorism. Also, the present petition, apart from being concerning the policy of the Union or the Election Commission of India, also does not show as to why the petitioner has directly approached this court under Article 32 without availing of an alternate efficacious remedy under Article 226. Paragraph. We are therefore not inclined to entertain the petition. Petition is dismissed.
Not only one, my lord, branding, my lord, for publicity, my lord.
We will do whatever you want to do.
Your lordship may just, my lord, your lordship, my humble request, my lord, I have done, my lord, I have from this court, one of my intention, my lord. Your lordship may consider, my lord,
You
that.
have been already saved once of the contempt. We want me to again issue one notice one.
So, Lord, may do one.
I have saved you once in contempt matter after holding you guilty of contempt.
Your lordship may only one request, my humble request, my lord. Your lordship may not permit me to withdraw this petition, my lord, with liberty to go to the High Court at least, my lord. That may be, that.
You are allowed to withdraw with liberty to take such steps as are permissible in law.
Lord, High Court, my lord.
As are permissible in law.
Lord, High Court, my lord, may be directed, my lord, to expedite the matter, my lord, at least, my lord. It takes.
We are just now saying that we are not superior to High Court. We don't need to issue any directions to the High Court. You must have heard that. Don't make these gestures.
Pardon, my lord.
Don't make these gestures again.
Thanks, I leave it to this court, I said, my lord, I did not.
Don't make these gestures and don't show faces to us. Otherwise, you will be inviting. I am the last person to send anybody under.